Well, welcome everyone to tonight's Keeping the Bench and Bar Together. I have the pleasure tonight of welcoming the Honorable Clinton Canady to be with us. As I believe most people on this call know, Judge Canady currently sits on the 30th Circuit Court. And Judge, I just want to officially thank you for your time tonight. We do appreciate it.
Well, it's always good to appear with several familiar faces.
Something that we've been missing, right?
Yes.
Well, just to let the attendees know, if you haven't attended one of these before, this is going to be a less formal meeting format. We do have some questions to ask the judge that have already been presented to us ahead of time. But if at any point in time you would like to ask the judge a question, raise your hand using the raise hand button, and both Chris and I will do our best to make sure to watch for that. You can also submit questions by typing them either into the Q&A or the chat as well. And if you want, there is a function to do that anonymously. You have that option as well. So feel free to interrupt at any point in time with a question by either raising your hand or typing it in the question box. Okay. All right, then let's get started here. So Judge, I know that you've been on the bench for a while now, but can you tell our members about your work before taking the bench?
I was in private practice for all of my career prior to the bench. I was with Stuart Dunnings for 13 years. We had Dunnings and Canady. Then I had my own office up to the time of my election. So I was in the general practice area, did criminal law, personal injury, family law, and estates primarily. So pretty well-rounded. I also did a lot. I was on the federal CGA, Criminal Justice Act panel. And I tried to recruit some more people there because they pay a lot better than the county. They really do. And I did get Tom Clement. You guys know Tom. We did get Tom Clement to the panel. And then he went into the state court administrator's office. And then we got Julie onto the panel but she ran for the courtship in Eaton County. And so Lansing needs to be represented. They're still looking for Lansing representatives, if anybody's interested. But I did that. I did a lot of juvenile work also. So I felt that when it came time to running for the bench, I had a background in most of the areas that we would be handling.
Interesting. So what made you decide to run for the bench?
You know, I never really aspired to be a judge. I really didn't. I kept telling people if I was going to be a judge, I have to do it by 2010 because that way I could get two terms in before I aged out. And they had asked me before to consider it. I'd always turn them down. But on this one, it's just the cards were lined up. That's the best I can say when you have an open seat. And I was encouraged to seek that out again, and I did. And, you know, I had done a lot of TV advertising for the practice. And so I think that had increased name recognition. And so that helped a lot.
And what have you found to be your biggest challenge as a judge?
Challenge?
Yeah.
I've missed the action, frankly, from from the office. I missed the action. You know, as a friend of mine would say, for you people who are still in private practice, you know how you come to the office and you're early and it's sort of quiet, but you're there and it starts to hum, and if you're there later and you're making money, it buzzes. And so I missed that portion. I missed the interaction with the attorney. So I had to work really hard to stay connected as much as I could in the role of a judge. You know, some of the judges like sort of isolate and don't want to participate anymore. So I tried to stay active in the local bar activities and got elected to the Board of Commissioners, serving 2 terms there. So that keeps me involved with the practice. So the biggest difference was this, that that air, or what would I call it? That air. Well, you guys in private practice know what I'm talking about. That's what I miss the most.
Well, and we certainly do appreciate all the times that you've helped out with the Bar Association. Keeping good communication, I think, is helpful. We talked about a challenge, but what do you like most about being a judge?
Well, I mean, circuit court judge has a lot of impact on people, especially since we're really trying to be more rehabilitative and intervention oriented. I mean, that really is the thrust right now, to try to give people as many chances as we can before you have to incarcerate them, unless it's a serious major crime. And so I think the number of specialty courts, I have the Swift and Sure program, which, you know, we're battling with the legislature now to keep that program alive. But really, I try to explain to them the Swift and Sure court is not an intervention court. Like your drug court, your veterans court, your mental health court, they're all intervention courts. But our court is definitely rehabilitative, and our population is definitely, how would I say, seasoned players in the criminal justice system. And so trying to get them to think differently. So we have about a 50% success rate, which I think is outstanding, because most of the participants in that program have either already been to prison, often are on parole, and have had multiple previous probation failures. So it's the last chance for them. And I let them know, this is the last chance. You won't be able to say that the criminal justice system didn't give you a chance to avoid incarceration. So I think that's one of the biggest positives.
I can definitely see that. Well, Judge, we were talking a little bit before we went on officially recording here. Let's talk about some of the changes since 2020. So how is your courtroom operating now?
Well, we don't have any jury trials. We do get a weekly COVID update, so to speak, while the numbers are going down. And I see we have Judge McCormick and Judge Stokes on, that the numbers are going down. We haven't met the necessary barometers yet set by scale. And then also the health director, who is, we have to sort of get her approval also, is still concerned about the high hospitalization rate and the number of people in ICU. So we're still at phase one. So phase one means that everything is on Zoom. So except in family court, I think they still come in on some matters, but in the trial division, general trial division, everything's on Zoom. Under our plan, the next step would be phase two. So phase two, the Supreme Court is pushing forth the idea of hybrid jury trials. So a hybrid jury trial would be where you conduct your jury selection by Zoom, then bring everybody into the courthouse with a rapid testing program. So apparently we received some funding where all potential jurors who are, the only ones that would be coming in would be the ones that are selected though. And so that is what's eligible in phase two. I think Judge Aquilina is the only one who's done one or two hybrid trials before we were shut down entirely. I think I would consider hybrid jury trials for civil trials. I don't think I would consider it for criminal. So before we can have actual criminal trials, it's you have to get to phase three. And then still we'll have a testing component, and we have a space allocations that we're working out if more than one judge is there. Currently, my courtroom has already been accommodated for socially distancing, so the jury is all set up. All my jury holding rooms are all set up, but that's only one judge trying a case at one time. So if you have two or more judges trying the case, we got the jury assembly room, which is the main access point, which we would like to use as a jury deliberation room, but it's difficult if you have other jurors coming in. We have to probably go over to the Grady Porter building where we can use the IT training room is large enough for social distancing, and the commissioner's room for that. So everything's on Zoom for me. And I was telling Lindsay before we came on, I'm going to stick with Zoom myself. I think the attorneys like it. I like it. I think it's a lot more efficient for everybody. Defendants like it in criminal cases because that means they probably aren't going to jail that day. So they like it too. And the Supreme Court pretty much has said it's up to the individual judge as to what they want to do. And so I believe I'll continue with that, except for some sentencings and criminal jury trials. Of course, on the trial division, the biggest problem we're facing is the number of people who've now been in jail, some almost 2 years, waiting for a trial. So that's a real issue. So once we get started, we'll have to get those started right away. And that's really caused, I guess, a philosophical difference. Basically, you try to release everybody that you can, but there's still a significant number that have just serious felonies, murders, rapes, home invasion first, bad records that have been waiting for a long time. So that's an issue for all of us, including the Supreme Court.
Well, and let me ask you about that, Judge. So you were mentioning that you might consider hybrid trials for civil cases, but not for criminal. So from your perspective, does that mean that you might start criminal trials before civil, or that you might start civil trials before criminal trials?
I might if I have some cases. What we try to do now is look through the cases and see which, if it's a 1 or 2 day trial. So I can't really make that decision until we get to phase 2. And maybe it might be in 2 weeks. I don't know, 3 weeks. Hopefully it'd be that way. But I probably would consider that because you don't have as big a pool of people to deal with. You're only going to have 8 jurors maximum that come in. And I think everybody would probably go for it. The requirement is that both sides have to agree to it. So somebody wants to have it in person, they'd have the right to do that.
And Judge, what are your thoughts on why the hybrid jury trial might work for a civil case, but not for a criminal case?
Well, I think you don't have as many people to select. You have a lower number of peremptory challenges, so you can get it done relatively quickly. And how would I phrase it? Anytime you're dealing with civil versus monetary versus criminal and incarceration, it's like a slight difference there. So I think that from a criminal standpoint, some attorneys, I might offer some attorneys the opportunity to do it. There has to be an agreement, but having been a defense attorney myself, I would never consent to that. So somebody might, but I think for me, I probably would look at the civil side more. And even after COVID, I would probably be amenable to doing jury selection by a Zoom hybrid, because I think the attorneys, especially out-of-town attorneys, probably would be willing to do that. So for the civil people, though, I mean, it's like I can't tell you when. Really. It's going to be after we get to the people in jail, which I think is probably like at least 3 or 4 months after we open up. So realistically, it might be like early next year before we get to the civil docket.
Okay. And you mentioned that you like Zoom. Besides the convenience for attorneys, have you noticed any other benefits of remote hearings?
Well, I think it's a better efficient use of time. I mean, when you had to come to the court and wait for your case to be called, it's kind of hard to do anything. With Zoom, you're at the office. So in theory, you still could be working on some other matters, waiting for your turn. I can control, we're pretty good on our time allotments for the cases. So we don't have any like super long delays, maybe once in a while, 20, 25 minutes, but most of the time it's pretty efficient from that standpoint. I like it. People don't have to come to the courthouse. It's more convenient for everybody. I think it's a good platform. We also have, in order to be compliant, I want you all to know I have about 350 followers on YouTube.
New, Judge, huh?
So, we have to have a live streaming on YouTube in order to be in compliance with the actions being open to the public. So now in some serious criminal cases, I have allowed the victims to come into the courtroom that they didn't really want to appear on Zoom, which I would have allowed them to do. Some appeared on Zoom, some wanted to come into the courtroom. So that's about the only people I've allowed to come into the courtroom. And I have some people waiting for corrections to start transporting again because they want to be in the courtroom on their various motions, which I keep telling them that just means it's more time before we can make a decision. But I have 2 or 3 files where the defendant's just insisting on being present. So I have to wait till they transport.
Okay. Well, and we talked about the benefits, but have you noticed any particular problems or challenges with the Zoom remote hearings?
Well, I think the technology has improved over the last year with the number of people using it. So I can't think of any snags that are so severe that we can't work with them. A lot of times the criminal defendants in that area may be in low bandwidth areas. They may be trying to work and come out and handle their hearing on a break or something like that. And so the connection isn't that good. So on preliminary hearings, we're still able to use the phone. I call that a hybrid Zoom hearing. So once I'm able to identify you, we can put you on the phone where you're having difficulty. But I've noticed quite a few defendants, I'm not going to say quite a few, some have that bandwidth issue.
Have you noticed any problems with exhibits or documentary evidence?
No, because most of the time I would have them send me in the documentary evidence if they're stipulated to, so that I could see it in advance. We still can show the exhibits on the Elmo, or we still can put them on the screen. So we've been able to make that adjustment. I haven't had any real issues with exhibits. I've seen some real fancy presentations.
Have there been certain things that you've seen done really well that you'd like to see more attorneys adopt when doing their hearings remotely?
It's never changed. It's the attorney that does well is the one that's best prepared. that has not changed. And so when the person comes in and isn't prepared, I mean, it's, and I guess the other thing is, when you have those litigants where we'll say their position just isn't that strong, and you ask questions and they want to go back to the main trunk line. And I have to say, well, I think I understand what you're saying on that, but what about this question? So, but really it's always best preparation. It hasn't changed.
Okay, and as far as how, besides being prepared, how attorneys could handle things better before you remotely, any advice on that?
Well, I think some attorneys don't want to think it's a court proceeding. So I sort of think you still should have your tie on or jacket or something, as far as that's concerned. I think on the civil side, that's really not much of an issue, but sometimes I think the attorneys could talk with their client more about the Zoom process or appropriate dress. Hasn't changed from the courtroom. And I think they could do that.
Okay. How we've heard from other judges at these that they've had issues with judges' copies for certain motions or whatnot remotely. Have you had any issues with that?
Well, sometimes they're a little slow. So, I mean, my policy pretty much is if it's not there on time, I'm not going to read it. Just to be frank with you, I have too much stuff to read. So if it's not there timely, I'm not going to read it. So, but we are getting the judges' copies, but they aren't as fast as they were previously.
Okay, do you have any?
So I guess people can focus on getting the judge's copy. Remember, they're supposed to deliver a judge's copy at the time they file, but that doesn't always occur.
Okay, and that was what I was going to ask. Is there anything that we can do as attorneys to help you get that information timely?
Well, just get out that it needs to be filed at the same time the original pleadings and clearly marked, and then they get there pretty rapidly. Before COVID, of course, a person could sort of always hand deliver their copy up, but now they can't do that, which causes a delay. So I can't say that's on the attorneys. It's just the policy existing in the building. So they can't bring it up themselves right now. So it causes a little delay.
Okay. Anything else that you would like attorneys to know about practicing in your court, from 2020's changes going forward into this year? Well,
I mean, I think I'll continue with the Zoom almost 100% on the civil side. I can't see, I like it that much, and I think the litigants like it. The criminal, I'll still be doing pretty much everything but major motions, trials, and sentencings on Zoom going forward. I think it's here to stay. I know Chief Justice McCormick supports these new thrusts, we'll call them. And so we were at our judges conference, and she was telling me I should look at the jury selections in Arizona and Texas. I wanted some guidance on what to do. So I think it's moving more efficient administration of justice is what it results in, and a more efficient use of the attorney's time. So that's a good thing as far as that's a good thing. I'm from the era where you used to have to wait a couple hours on Wednesdays to get in for a 10-minute hearing. So, I mean, now we don't have that anymore. So that's a big bonus.
Any suggestions for younger or newer attorneys who may be just starting out their practice on Zoom and may not have the courtroom experience of before Zoom? Do you have any advice for them on that?
Just be yourself. I don't really think that when you appear on Zoom that you have to appear any differently than you did in person, frankly. You might be sitting down rather than standing up. But I think it's the presentation is you're still a litigator. And if you're a litigator, the presentation is the same. Clear, concise, short, to the point. And by the way, as Mr. Stevenson reminded me, Judge, this is the law.
Well, thank you there. Is there anything else that you wanted to say, Judge, before I open it up for questions?
Well, the practice of law has changed so much since I've been here, especially on the civil side. I think the defense attorneys don't have as much autonomy as they did back in the day. And so there's a lot of, I guess, statistics and background. And so I think a bigger change has been that the lawyer, in some instances, has become the technician, the qualified, highly skilled technician, but isn't the one that's making the final call on the case. So that's a major change on the civil side that I've seen. On the criminal side, I think it's like client control. I mean, having been on the criminal justice panel, so, and most of our cases are handled by the defender's office now, all right? And so the defendant itself always is skeptical that they have a court-appointed attorney. So first you have to overcome that. But it's, I've noticed a hesitancy sometimes just to tell the defendant the truth. Really, just tell them the truth. And they want to take the position, my client says this or that, but it's really a case that they are not going to be able to win. And so sometimes I think attorneys don't have sufficient client, nor have they established a rapport with their criminal defendants to try to get them to look at it. I always used to tell people, if you were on the jury, what would you do? And so that got a lot of movement. a lot of movement. But I think that's a skill. Now, and I've been thinking about that a lot. I mean, I don't know how you train that. I had a mentor, so I had Stuart Dunning's the father, so I had a great mentor. So probably mentorship is the best way. But I don't know, maybe they could come up with some type of seminar for client control. It's always difficult because it's a fine line between having client control and representing your client's best interest. Because a lot of times when you're talking about what's in their best interest, they think you aren't fighting for them. So, I mean, the role of a criminal defense appointed attorney is difficult. It's difficult, no doubt about that. So.
Thank you very much, Judge. I appreciate that. And at this point, I would open it up if any of our members had any questions that they would like to ask for the judge. Don't be shy.
Hey, Judge, Jamie White here. How are you, sir?
Fine, Jamie.
Good. Thank you for taking the time out. It's very, we're very grateful for that. You mentioned that the Swift Insure program is under some form of scrutiny. I was not aware of that. I guess, could you give us just a brief overview of what's going on there? And then more importantly, what we can do as a local bar to assist in keeping that program moving forward?
Well, the representative in the House who sits on the Appropriations Committee and on the Corrections Committee doesn't like the Swift Insure program. I haven't been able to figure out what her basis is, but she has defunded it in her budget proposals for the Republicans. And so I think we can contact her, contact our representatives to say that we need to stay in. I've just authored a letter that I'll be distributing tomorrow concerning that. And so I don't know if it's, I don't know what her motivation is for picking on this program, other than perhaps she doesn't understand that it's a different population than the intervention courts. And our success rate, say, is equivalent to the success rate in sobriety court. So letters, contact the councilman. I have some information at the office. I've written a letter that I'll be distributing tomorrow, like I said, that I think lays out the why we should have this and why it's been a success. Because one of the big things on probation, and that is the Swift Insure program pays for everything. We pay for the drops, we pay for the counseling, we give you a bus pass, we do everything. And really, for many of these participants, that's a bonus. I mean, they don't have to come up with the money for the drop, they don't have to come up with the money for the counseling, and even get them some transportation, give them bus passes to make sure they can get where they want to go. And so those small things, I think, and then it's a dedicated probation staff that's on the Swift Insure, and the staff I have, they do an excellent job, and they make sound decisions. And so hopefully, I know that the state court administrators and Supreme Court want to maintain the program, so we'll have to see how that shakes out.
Thank you. Anything we can do, please let us know.
We'll do.
Hello, Judge. I had a question. As courts start to open up, we're going to be pulled in different directions for jury trials. I was wondering if you had advice on whether we should contact the courts as soon as we know of a conflict, even if we think one of them is going to work out, or tend to put it off, or what's your advice, at least when dealing with conflicts before you, as far as what you think that process should look like?
Well, on the civil side, the rule already is that the civil attorneys, if they have a conflict, have to let the court know. Okay. On the criminal side, it's pretty much, for me, it's pretty much a 30-day notice, and we use a specific day. So in other words, if I say your trial is going to be on May 15th, it's going to be on May 15th. It's not that we're going to call in several other cases at that time and go with whichever one goes first. So we're going to go on the 15th. So it's a matter of keeping us apprised. We'll try to work with you, but usually it's whoever starts first, or the oldness of the case, that's a factor, or the type case too, that's a fact. Whether someone's in jail or whether someone's on bond. those are factors that we have to take into account.
Thank you, Judge.
Other questions for us? I see Judge DeHoven is with us.
Okay, I think you're muted.
Judge Larry Nolan, are you taking pleas in the courtroom? Are you doing pleas, if there's a plea bargain, a guilty plea, are you taking them in person in the courtroom, or are those being deferred to Zoom as well?
No, I do my pleas on Zoom. A person has a right to have it in person. Once in a great while, somebody will want to come in person. Sentencings I'm doing all by Zoom too. But again, the defendant has a right to have it in person. I think I've only had one defendant that wanted to have his sentencing, maybe two. I had a person that was at corrections and wanted to come back. For sentencings in person. So I do that on Zoom. I do it all on Zoom. Like I said, the only time I have people come in if they have some victims that want to come into court and be present, I will allow that. But if a defendant requested in person, I'll do it, but I haven't had that request. It hasn't been an issue.
And the same with sentencings?
Same with sentencing. So if I want to remand somebody, I usually will tell them to report. If I know I'm going to remand them at the time of the plea, I'll have them report before sentencing. Then the Zoom hearing would be conducted from the jail.
Is that a policy of the circuit?
It's not a policy. I think each individual judge can do it any way they want, but it's not a policy. That's just how I operate. So say, for instance, somebody pleads and has a felony firearm, I know they're going to be doing 2 years, okay? And I'll say, well, you might as well go and get started now because you'll get out earlier rather than waiting. Cases like that. But the vast majority of them, I leave out till sentencing. Because, we really ramped up the alternative programs that might be available for defendants to avoid incarceration. We've also improved the in-house services in the jail. So one of the big benefits of the millage was that the services can be provided to inmates pre-trial. All right, previously they had to have been adjudicated in order to get services from the jail, but now they get services from the time that they get there. So that helps too. That helps in sentencing, helps understand that somebody's already in programming. Maybe we can just continue it. So I think one of the biggest changes is we have a lot of options and alternatives to incarceration. That's really sort of like the last line of defense. So I think I do on Zoom. I can't 95% everything's on Zoom. And so in order to reduce my backlog, now I've been getting a lot of calls because I did this. What I did was I took what I would call the low-hanging cases where people like resisting and opposing, not retail fraud, fraudulent transaction devices, R&Os, non-domestic violence, assaults, brought them in and worked out a lot of cases. Because I took the position that if your case was a 2019 case, here we are in 2021. So you've been on pretrial release for 20 months. Then my position was, I want to treat that like probation. So if we can resolve the case now, I'll give you another 6 months probation. I'll give you another year probation, but I'm going to treat that time that you've been on pretrial release as just like probation. And that was popular, put it that way. That was a popular way to dispose of some of these cases.
I think that if a defendant has been on bond for 2 years and he's adhering to the requirements of the bond as far as drops or testing or whatever, that would probably go a long ways to shortening incarceration and or even probation if the person was complying with everything that the court might order in a normal sentence.
Yeah, we had a couple of people who had been maybe 20 months, 22 months, no problems, and no major prior record that I didn't place back on probation. We had some in conjunction with my prosecutor where maybe we could he could offer them a misdemeanor of some type. And a lot of those, I just sentenced them immediately. I mean, I couldn't see overburdening the probation department with another pre-sentence report. And so I did that with those just to try to get the cases down. So tried to be innovative with that. You know, it's always a fine line. You know, can't browbeat anybody into doing something, but try to give them some alternatives. Well, a lot of times when I'll ask my prosecutor in front of them to say, well, tell me, what do you have in the case? I mean, that has helped a lot too, where I'll say, well, why don't you proffer? Tell me what you think you're going to be able to prove. So, you know, you have the case where the guy, this is where the guy is has a CCW in the vehicle and it's in his pocket when he gets out of the car. You know, so to say, well, I mean, you're entitled to a trial, but what do you want to do to it? But I have a new one that made the top 5. I'm telling everybody. So I had a guy, he's pulled over, he stopped, he's on probation. They find a crack pipe in the car. And I said, well, what happened? He says, well, I picked up this vagrant and the vagrant wanted me to give him a ride to the store, which we assume was the liquor store. And as he got out of the car, the police came up and wanted to know what was going on because he was a known criminal. And so I said, oh yeah. So what, are you trying to tell me that the crack pipe was placed there by the vagrant? And he says, well, it must have been, I don't know. I said, well, how did they find it in the driver's side door well? So I told my probation agent, that ranks up there with the person who didn't make it to his appointment because he happened to drop his phone in the commode and lost all his dates. So a lot of dates. But I want to commend the civil bar because the civil bar has worked vigorously to resolve cases where they can. And so I think we're appreciative of that. They have been doing that. And so some cases, of course, just can't be resolved. But where they can be resolved, I've noticed, and I commend the civil bar for those efforts. It's much appreciated by the board.
Hi, Judge. Not to put you on the spot, just wanted to know if you have any funny or ridiculous moments on Zoom you can share. Anything come to mind?
Well, I have some sad ones. Well, this week, this week we had one where the guy missed a hearing in the morning. So, you know, they're changing the bench warrant rules. So now you have to give him 48 hours coming up. So I said, well, look, if they call me, so we can get him here in the afternoon. And I guess he must have been on I-96 somewhere. He's driving. I said, I can't hear you. You're going to have to pull over. He must have been in a small car. And so he pulled over and those trucks rolling by. And I wanted to tell him maybe he should go to the nearest exit. I mean, the trucks were whoom, and the car was vibrating. He was being jiggled around by those trucks. And so we had to work extra hard for that. I don't know. You have those same situations where a person claims they fall asleep on the Zoom call. So having things like that. Don't know. I don't know. My client was saying they were going to be there. And then the one now that we have to work with, you know, in the population that we work with, successful techniques get out fast. It's like they must have a telepathy or something. So now it's like, well, you know, I just tested positive for the virus yesterday. You know, I said, well, get me some type of confirmation. Nobody's ever been able to do it in under 2 weeks. So it's always how that is. I think I've contacted the virus. Okay, well, we have to work with that with you. A few years ago, the one was, especially on probation show causes, right before the hearing, like a few hours before, they go to the emergency room and say, I had to go to the emergency room for some phantom problem. And that's why I wasn't there. So we learned to roll with those punches. Any other questions for me?
Judge, this is Scott Mandel. Thanks for doing this. Really appreciate it. Do you ever see a role for a Zoom type trial, including a bench trial, at some point down the road?
Bench trial, maybe. Okay, maybe. And in civil, I think maybe it's a bench trial. I don't see it in criminal because you have the confrontation rule. You have the nuances of witnesses, cross-examining witnesses, which really can be very important in, say, a criminal case and in a civil case too, where you have, say, alleged malingerers or things like that. And the demeanor that the person testifies in, I just don't think can be captured the same as in the courtroom live, okay? You know, your video depositions of experts and things like that still probably will roll, but I think when you're talking about the principles, everybody would have to agree. I mean, it's technically possible, let me put it that way, but I wouldn't see very many people agreeing. They want to see the witness. And then, you know, the thing about Zoom and having witnesses testify is, and I was telling Lindsay before this, you got people in the background, you know, especially with your jurors, the husband might be listening, or the girlfriend, and they're, you know, just in the course of business, we can tell them all we want, that they shouldn't have any communication, but if they're there, they hear it. I think that's a issue that we can't solve. The only way that we can limit that, and we really can't solve it in a regular trial when they go home in the evening, but most of the time, the person hasn't heard it per se, okay? Because I would imagine that when we go back to live jury trials, we will not be on, well, maybe. We may still have to be on YouTube because we have a space limitation in the courtroom, but we also have the room that has the video set up that we used to use for attorneys that contact clients in the jail and things like that. We have that as the overflow room. So as long as we were using that and that wasn't at capacity, I think we would not have to be on YouTube. But otherwise, we might still have to be on YouTube depending on how many people are there. Right now, that's really limited. In my courtroom, the jurors, if you recall, take up 1/2 of the left side. So that would be the south side. They take up all that space. Then we have on the far right side, the defense counsel and the attorneys are socially distanced from everybody, but that pretty much takes up that other half. So the only seating area we have, I think it holds 10 people. And so we'll have to work with that because a defendant might have some family members. They'll have to choose. The others will have to go to the overflow room. The victims may want to have some family members, but they'll be sitting in close proximity rather than on either side of the aisle as they are now. So we'll probably have to have increased sheriff's protection I guess, preventative actions in that situation, because the number of people in the courtroom under the spacing is limited. I think there's some discussion about stage 3. Maybe you wouldn't have to do that, but I probably will keep it for a little while, even after I get to phase 3.
And Judge, to follow up on that, we've had some different opinions from different judges. Some judges like to see the people in person when they can, even if they're masked. Other people feel that they get a better witness presentation on Zoom without the mask. Do you have any thoughts on that?
Well, I think no doubt the witness presentation without the mask is better. And those matters we have had live, we've had the people pull down their mask during the testimony. So I think that's almost like having it on Zoom if you have them, allow them to keep the mask on while they're testifying. So I've always had them pull it down so people could see full facial expression.
Any other questions for the judges? We have a couple more minutes here.
Hearing none.
I didn't say, it sounds like you answered everyone's questions, Judge. Good work.
Well, I'm glad
Judge,
to see everybody. Yes.
I have a question. Andrew Moore here. I work for Mr. Nolan down in Indian Rapids, and thank you for putting this on. I have a question. Recently graduated from law school. This is about law school. Do you think that Zoom and the legal education, this may have been asked of previous judges, but do you think legal education will change the fact that all classes are going to be remote, and the Socratic method is a very popular method in school that loses its allure over Zoom?
Ooh, man, I'm dating myself.
Any thoughts about that?
I've never had a class on Zoom, so I don't know. I have no idea how that would work. I think the information is still getting out there. But I loved going to school. I did. And so now I can't answer that. I don't know. Time will tell, I guess.
Do you think that it'll have an effect on future lawyers?
Well, I don't think it'll have an effect on the quality of legal education and future lawyers. But if people are more schooled on Zoom, they'll have a more polished presentation when they appear in court. That's how I see it. But Zoom is here to stay. I assume. I mean, you figure that almost all your administrative hearings they allowed to be done by Zoom. So I don't know, maybe in the next few years, the Supreme Court will lighten up and tell us what cases may or may not be done by Zoom. But all your administrative hearings are done by Zoom. All the evidence is presented, et cetera. We get those on appeal, but they're all Zoom hearings.
Thank you, Judge.
All right. Anybody else? I thoroughly enjoyed seeing everybody. So many familiar faces. Takes me back. You have anything house retirement, Judge Tehoven?
I don't even know if I'm running this machine right. I don't even think you can hear me. I don't know what I'm doing.
We can hear you. We hear you.
Oh, well, yeah, my court administrator set this kind of stuff up for these last 15, 16 months, and I didn't know what button to push or where I was talking or should be looking at.
Yeah.
I became the poster child for mandatory judicial retirement.
Well, I tell you, my law clerk, Ryan Weir, is a technological wizard. So when I have a question, I turn to him too.
I keep looking for that person, but I think it's about my 10-year-old granddaughter knows a lot more than I do about a lot of things. So
it's like it's like my grandson. I don't know. He was looking up something. He's like 11, and he's like, well, I can do it for you.
That's right.
Or OS, you can get that through your phone, Grandpa.
Well, yeah. I kept pushing buttons here. I didn't know how to get any of you on the picture. I didn't know if I was muted or unmuted. Finally, I found a bar I touched and some things happened, but not enough. But it was a wonderful session, Judge. And I'm doing this because I'm kind of half practicing over there with Fraser Tabelcock on mediation, maybe. So we'll see. So Houck and Judge Houck and Judge Manderfield and I and a couple others. So
Good.
yeah, I never was too convinced that mediation was really as good for retired judges as some retired judges seem to think. Of course, not Judge Houck or Judge Manderfield; they do fine. But I think that you could settle cases when you had the robe a lot better than you could settle the case when you were just another voice in the room.
Yeah.
Right.
Are you sure you want to try that one?
Yeah, we'll see what happens. I don't know. I may not be there long. You never know.
All right. Keep up the good work.
You do the same,
Tom
Judge. It's
Woods,
wonderful.
what about you? How you doing?
Good, thanks. I'm still practicing mostly receiverships, and I was just thoroughly surprised to see Judge Tavonen join this group. I've attended 4 or 5 of these now, and I've quite frankly enjoyed them all and learned something, and
Tom Woods.
I can learn some more.
All right. Outstanding.
I'll echo that. We're getting close to time here, so I'll wrap up here. But Judge, we really do appreciate you showing up today. And the whole point of this was to keep the bench and bar together when we have to be physically separated. So I hope tonight accomplished that for all of the attendees and the people who will watch it in the future.
All right. Thank you all. Keep up the good work. That's all I have to say.
Thanks, everyone. Thank you, Judge.
Thank
All
you.
right. Thank you.
Thank you, Judge.
Thank you. Nice to see everyone.